Hi, this is Chris German from The Apartment Dealer. Welcome back to The Apartment Dealer Show. This is where we bring you the information, resources, and the network of professionals that will assist you as you build your financial legacy in multifamily properties. With me today, I have Mr. Michael Brennan. Michael Brennan has been an eviction attorney for the last 17 years and represents landlords like you in LA County, San Bernardino County, Orange County, and Riverside counties. Now, what has recently passed here in the state of California is SB 91, Senate Bill 91. It extends the eviction moratorium that was already in place and changes the rules by which how much and when tenants must pay rent. Mike is going to be with us to take a deep dive on SB 91 and probably many of the questions you have concerning collecting your rents, evicting tenants, and essentially making sure your properties are performing. Be sure to like this video, subscribe to our channel, and turn on the notifications if you're a landlord, you own investment property, and this type of information would be meaningful to you. With that, help me welcome Mr. Michael Brennan. So Mike, welcome back to the show.
Thank you very much, Chris. I appreciate being here.
So Mike, I imagine the last 10 months, you haven't had much of any business. You've just been twiddling your thumbs and just waiting for the phone to ring, huh?
Yeah, that's not at all what's been going on, Chris. The phone has been ringing off the hook, and the emails have been flying in furiously. So, no, I am not sitting around waiting for things to happen right now.
And we thank you again for being gracious with your time. The landlords, obviously, given all the recent new rules and regulations, there's a new essentially sweeping law that's been passed here in California, Senate Bill 91, SB 91. And it seems like over the last 10 months, every couple of months, there's something new. And again, you've been gracious enough to really do a lot of these educational type settings pro bono. So thanks again, Mike, for being with us.
You are very welcome. I love helping you guys, and I love helping your clients. Hopefully there'll be more my clients one day.
So before we jump into SB 91, I wanted to go through a couple rapid fire questions that I'm consistently getting from our clients that are maybe outside of SB 91. So just a real general question, are the courts now open? Obviously, there was a period of time in 2020, they were essentially closed. Are they now open to hear cases? And if they are, what's the general timeline to get in front of a judge?
So I'm going to break that into two categories. It's a good question. I'll break it into categories for pre-COVID cases and a category for the cases that are coming up now. So the pre-COVID cases, yes, the courts are reopened. A lot of it is still done digitally, meaning we don't actually go into court. We're doing it over something like a webinar or a Zoom meeting, something like that. But yes, those cases are working themselves through the court systems. And the speed of it will depend a lot on the county, the judge, or the court system. For example, LA County Superior Court is slower, but you have, it would be slower than, let's say, a Riverside Court. And then within LA County, you have some judges that are just pushing stuff through, and other judges that are creating additional hurdles that landlords have to jump through or jump over before they'll move a case forward. So a lot of it is location specific, and a lot of it is judge specific. If you have a more tenant friendly judge or a tenant sympathetic judge, I'll say, they'll be the ones who are moving slower. They don't want to make mistakes. They want to provide the tenant with all the protections they can get. If you have, there are judges out there that they're just as tired and fed up with this whole stuff as we are. And they're the ones pushing their cases through and making decisions and doing somewhat business as usual. So that's for the existing cases. As far as brand new cases are concerned, yes, even those can move forward. And again, that gets broken up into different geographic locations. So for example, the city of Los Angeles, their moratorium prevents you from even serving notices. So there's not really anything you can do in the city of Los Angeles. You're not getting a case into court in the city of LA without violating that moratorium. I do have clients that are willing to violate it, and they'll say, Mike, serve the notice, file. And if the tenant comes back and gives me my 15-day warning, that I have to rescind it, I'll rescind it. But in the meantime, I want to be aggressive. I want to move forward. Go ahead and do it. I have other clients that say, no, I don't want any liability exposure. Let's not serve notices. So in LA City, which, let me clarify what I mean by LA City. LA City would include cities that people traditionally don't think fall under LA, like North Hollywood, Encino, any of those cities in the valley that would be hit by LA rent control. That's all LA City. So those cases generally are not even getting into court right now. LA County, once you get out of LA City, LA County's position is that their moratorium has been extended and you can't serve notices under them, et cetera. There's debate about that because their moratorium was worded differently than LA City's was. So those cases, we disagree with LA County. And I'm not going to get into the analysis right here because it will probably be misinterpreted by somebody. But for properties located in cities that are not part of Los Angeles City, cases are being filed and we are moving forward. You get outside, let's say, for example, in Long Beach, yes, cases are going forward. Inglewood, cases are going forward. So we're in court on a daily basis, but I can't give you a blanket statement. Yes, all cases are going forward, or no, all cases are not moving anywhere.
And so that's a good point about the difference in areas. And so I want to preface the rest of my questions with this statement. Much of what Mike will address today is in general under whatever law we're speaking with about, whether it's SB 91, AB 3088. Within those guidelines, some individual municipalities like LA County Unincorporated have their own version of rent control and have their own rent freeze that's in place. So this way we don't have to keep saying, hey, it might be different. Just keep in mind, you will always want to check with your municipality, the city of which you own in. Hey, this is the way I understand the law. Do you have anything that's outside of the law, in addition to the law, to protect yourself? And you want to make sure you're working with an eviction attorney that is well aware of what's particular to your area and your city. Now, aside of issues for non-payment of rent, nuisance, laying waste to the property, if I'm hearing you correct, these cases are moving forward.
Correct. Even, I want to be clear about this, outside of LA City, for example, even non-payment of rent cases can move forward right now if the tenant does not return that declaration. So let me just throw that out there. If the tenant is served a 15-day notice and they do not return the declaration, you could file an eviction today for non-payment of rent. There's some caveats to that. And if you want to know the caveats, really pick up the phone and call an attorney so that they can walk you through. It's very nuanced. But going back to your question, that is correct. You can still file evictions for breach of contract, other provisions within the lease. For example, unauthorized occupants, unauthorized animals. Let's say, the tenant keeps parking in the fire lane and the landlord is getting cited by the fire department. Any sort of a breach of lease can be filed in the eviction court right now. But again, like you pointed out, Chris, you've got to go to your local moratorium and figure out the parameters of the local moratorium, because going back to LA City and LA County, both of those in their moratoriums clearly state you cannot evict somebody for unauthorized occupants or unauthorized animals or even nuisance. So theoretically, in LA City, for example, your tenant could walk up to your on-site manager and beat them up, and I would not be able to evict them in LA City for a nuisance. So yes, in general, under, for example, SB 91, all of those reasons are perfectly acceptable cases to bring in eviction court, but you've got to go back to your local moratorium and see if that's permitted under that moratorium. And you also have to ask yourself, is that moratorium still in place? Most of these moratoriums expired back in September in most of the cities. I'll give you an example. El Monte, I was just looking up yesterday. El Monte's moratorium expired, which leaves them under LA County's moratorium. LA County's moratorium expired for residential evictions on September 30th, which means they're left with SB 91. And as I said earlier, LA County's moratorium, there's some debate whether it's expired for residential evictions or not. The county is saying, no, I'm reading the clear language of the state law that says, yes, they can't extend it. So Again, this is why it's nuanced and you need to talk to an attorney. But yes, you can bring cases in eviction court depending on your geographic location.
With respect to the eviction process, other than some of these cases are being heard on Zoom and so forth, like you mentioned, has there been any other general changes to the courtrooms, to the process that landlords should be aware of as they're gearing up for their case to be heard?
There have been subtle changes, but they're not changes that a landlord would need to take into account. I'll give you an example. Just yesterday, when you serve somebody with a summons and complaint, there's different ways that they could get served. If they're evading service, you would do what's called an order to post, where you submit a request to the court that the court would normally sign, which would allow you to post a copy of that summons and complaint on their door and mail them a copy, instead of actually having to hand them or somebody else at the property a copy of that summons and complaint. And that gets the case started. Just this past week, we had a judge reject our order. He refused to sign it to allow us to post, stating that we hadn't included enough details. He wants to see more details now in a document called our Declaration of Due Diligence. Now, his decision is an internal decision. We've never had that document rejected, ever, not once. But now he is going outside the code and he's saying, well, this isn't enough for me. I want to see more. That's him imposing his own preference. It's not law. And he's doing it on a procedural law that the landlord really doesn't know anything about. It doesn't matter to the landlord, except that the landlord wants to get the tenant served. But it doesn't affect how the landlord presents their case. Now, having said that, mentally, I think all landlords would be well served right now to understand and go into court with a mindset that says, okay, we are still in the middle of a pandemic. Not only has the city of Los Angeles and the county of Los Angeles, I'm speaking about Los Angeles broadly right now, but this applies to all counties and all over the state. The big cry right now is tenant protection, tenant protection, tenant protection. And so with that in mind, landlords would be well served to go above and beyond anything they're supposed to do to try to work with the tenants, to try to get the tenants on the same page as them, to be compassionate with the tenants. The same thing you and I were discussing 6 months ago. Because when you do get into court, you can anticipate that the judges have the mindset, many of the judges have the mindset that, hey, we are here to protect the tenants right now. We don't want to put people out on the street in the middle of a pandemic. And so if you're going above and beyond what you're supposed to be doing, and you can demonstrate that to a judge, at that point, it's very difficult for a judge to say, well, I need to protect the tenant. They look at the landlord and they go, the landlord's doing everything they're supposed to be doing and then some, and it should be documented. So for example, if a landlord is going back and forth with a tenant right now about non-payment of rent, the landlord should try to be doing this in writing, not having verbal conversations. Try to do it in writing with the mindset that anything I write is going to go in front of a judge. Mm-hmm. So don't say inflammatory remarks. Be very kind, very compassionate, ask about their family, ask how they're doing, tell them you want to work with them, but explain to them the difficulty that the landlord is facing. They still have to pay taxes, expenses on the property. Is there anything they can do right now? Is there anything that the landlord can do? Just a very, very professional, polite letter, like I said, with the knowledge that that letter is going to go in front of the judge. And that's the kind of mindset that will help a landlord. But otherwise, procedurally and legally, very little, except a couple of caveats that came up in SB 91. So if you want, I'll jump into that right now, or if you want to save that till we're specifically talking about SB 91, I'll do it either way. It's up to you.
Yeah, let's save it. Couple more wind-up questions before we get to SB 91 is, so we have these two periods. We have the protected period from March to August of 2020, and then the transition period, which follows right after. So I have it, many of the landlords, even some of our clients we speak to, they're saying, look, during that period, because it looked like the world was ending, I was being extra compassionate. I really wasn't writing the tenant for the rent. So I wasn't giving them notices. I was just in communication with them because I assumed come September, I was going to have my day in court. And then come to find out that didn't play out the way it was. So if we have a tenant who didn't pay rent just during that protected period, and I haven't done anything about it, what do I do today?
First, let's break those periods up so that everybody is clear about what we're talking about. The protected period ran from March 1st of 2020 to August 31st of 2020. Then the transition period runs from September 1st of 2020 all the way now through June 30th, 2021. So for that protected period, all landlords were required to serve a specific, I always call it the tenant's COVID rights notice. I'm going to work on the assumption that all landlords did that. And now I'll answer the question based on that assumption. Assuming you did that, that does not mean that and you haven't done anything about that protected period now. That doesn't mean that you've thrown it away. What you need to do, if you haven't already done it, is serve a 15-day notice with the correct declaration for that protected period. And if the tenant returns the declaration within the 15-day period, then you'll never be able to evict them for that rent. But you still have legal rights that you will be able to pursue. Right now, it'd be July 1st. Under SB 91, you may actually be able to get compensated for that period. We'll talk about that in a little bit. But there are still remedies you can chase for that money as of July 1st, which is going to be a small claims action, civil action for breach of contract. That may get extended, we don't know. But as of right now, it doesn't mean that those rights are gone. They're not.
And so same question for the transition period, because obviously the documentation changed come September. So again, I'm a landlord, and you'd be surprised, Mike, I speak with these landlords, and sometime between September and now, the tenant didn't pay rent. They didn't execute any documentation. They were just in conversation. Now that they understand that the eviction moratorium has been extended until July, now they want to do something. Well, what's step one?
Step one is under SB 91, there is a new tenant's COVID rights notice that has to be served on or before February 28th. So that's step one. If they don't have it, Chris, and they contact you, you get my newsletter. In my newsletter, I had a link to that document. Mm-hmm. Forward that to them, have them download that document, and they need to send it. The law says they can either serve it, or which you would serve any regular notice, or they can send it by mail. But it has to be done before February 28th. If they're going to mail it, my suggestion is mail it on or before February 21st with some form of trackable delivery, like a certified mailing that does not require a signature. This way they can prove they mailed it. That's step one. Step two is slightly different advice than I was giving prior to SB 91. Prior to SB 91, I was telling everybody, hey, wait until January and serve your notice then, because you'll have all 5 months stacked up. You'll know exactly what they owe. Now that it's been extended, I'm telling landlords, serve your notices every single month. Every month, serve a new notice, because for two reasons. One, it keeps the tenant aware of the fact, the way we're doing our notices and the way the law requires, you have to put in there the amounts that are owed, the dates they became due, any payments that were made, and it's almost like a ledger. If you serve that every single month, one, the tenant is aware every single month that you're not letting this go, that they're getting the notices, they're seeing the numbers stack up. But more importantly, once you serve that 15-day notice every single month, the tenant is required to return that declaration within the 15 days. And if they don't return the declaration, then again, the landlord is allowed to file an eviction action. So that's step two. Step one is serve that tenant's COVID rights notice immediately, because if you don't, you're going to waive your rights. Step two is every month from now on, start serving your 15-day notices.
We have AB 3088, SB 91. Does SB 91 change AB 3088?
It does in two ways. One, as I said, they're basically the same law, except SB 91 extends AB 3088 out to June 30th, 2021. It also provides some additional protections for tenants. For example, now landlords can't sell the debt. They can't assign or sell any unpaid rent debt prior to June 30th. That's an additional protection. So it does change it. Other than the extension of time, I would say that they're not huge changes. I don't know a lot of landlords that were out. In fact, I don't know of a single landlord that was out there selling the debt prior to SB 91. So I don't know that that's a substantive change. It is, but how many people is that really affecting? Yeah. Who knows? But there's not a heck of a lot of changes. Essentially, it's the same law now extended.
And so if I'm a landlord who's been lucky enough that I've collected every month's rent since March of last year, my wife and I, knock on wood, we've collected this entire time. But let's say come March 1st, a tenant does not pay. Do we have to notify the tenant about SB 91?
Yes, you have to notify the tenant. In fact, that's the tenant's COVID rights notice. I was just talking about that. And you have to do that on or before February 28th.
Okay.
Yeah.
And so there's this 25% that the tenants must pay. That 25, which began prior to SB 91, that they could pay if they claimed COVID, they could pay as little as 25%, and essentially this continued their stay. That remains the same. The tenant has to pay at least, even if they claim COVID, they have to pay at least 25% of the rent that's due.
They have to. So, okay, that is a fantastic question. And the answer is yes and no. Okay, what does that mean? The industry kept lobbying Sacramento, asking them to change AB 3088 so that the tenant had to pay the 25% monthly. That didn't happen. So yes, they still have to pay the 25%, but they don't have to pay it until June 30th. So all of this rent, even before SB 91, beginning September 1st, 2020, all the way through June 30th, 2021, the tenant has until June 30th to pay 25%. Now, you say of the rent that became due. Again, that's debatable. You have to, I see when I read SB 91, at least two different interpretations of that law. I'm not going to quote the language because unless you're an attorney, it's mental damage you don't need to go through.
Yeah, right. Thank you.
But what I will say is there is at least two interpretations. One interpretation says the tenant has to pay 25% of the rent that became due. So I'm going to use easy numbers. Let's pretend we're dealing with 6 months of rent at $1,000 a month, or let's make it even easier. 4 months of rent at $1,000 a month is $4,000. The question becomes, do they have to pay only $1,000? That would be 25%. The answer would be under interpretation one, the answer is yes. There's a different interpretation though, that I think many landlords could benefit from, but it hasn't been battled out in court yet. So we don't know how this is going to play out. Let me explain how that would work. Let's say rent is $1,000 a month and the tenant, the rent is due on the 1st and the tenant makes a payment in that month. Let's work in the month of February because that's what we're in right now. Let's say in February, the tenant paid $250 in the month of February. So they've paid 25% of the rent that came due in February. Now, let's say in March, they don't pay anything. So in March, I'm going to serve them a notice. And my notice is going to have $1,000 that they owe for March, but it's also going to have $750 that they owe for February. We on the same page so far?
Yeah.
So the question and the different interpretation of the law is, on or before June 30th, do they have to pay 25% of only the 1,000, or are they going to have to pay 25% of the 750 as well? Because the language of the law says they have to pay 25% of the amount demanded in the notice. So there is this possibility of at least two different interpretations of that language. So yes, the short answer to your question is they've got to pay 25% on or before June 30th, but 25% of what?
So this 25% is tied to them also returning the tenant declaration. The tenant essentially self-reporting that they were impacted by COVID. Okay, so
Correct.
they fill out the form. Now they're in the clear. We now hopefully get to court, say in August, sometime August, and the tenant does not have that 25%. They just don't have it. Is it true that, okay, then now the landlord gets the unit back and we go on our way? They either have the 25% or they don't?
Let me explain. Let's say you get to court. First of all, it's important for your clients to understand. Court statistics show that 98.5% of cases never actually go to trial. They set a trial and you show up on the day of trial, but most cases are resolved before they actually go to trial. So let's say you get to court, you can file on your 25% because they didn't pay it, and you get to court and they hired a tenants' rights attorney because that's realistically what's going to happen. And they demanded a jury trial and they're making you jump through all the hoops, but they really don't have that 25%. What's realistically going to happen is there's going to be some settlement, and that settlement is going to involve most of the time the tenant returning possession of the unit. And under SB 91, there's now one of the additional protections I was talking about is future landlords are not permitted to use unpaid COVID debt in deciding whether they will rent to an applicant or not. So the tenant will agree to vacate and give you your unit back, and they really won't have too much trouble finding a new place to rent. And they're still going to owe you all the money. But realistically, the tenant is in the negotiations is going to ask the landlord to waive all the back rent, et cetera. Now, the landlord may say, nope, I'm not going to do it. I'm not waiving it. We've gone over a year at this point. I want my money. I want a judgment. I'm willing to go to trial. And you can go all the way to trial, even if you're willing to go to a jury trial. And let's say you win. At that point, the court still has the right to issue what is called a conditional judgment. And what that means is that, okay, Mr. Landlord, you won, but we're going to give this tenant 5 more days to pay you the 25%. And if they pay the 25% within the 5 days, then they win. So they're still going to get that one last bite at the apple. So in general, that's not going to happen. Most landlords are going to negotiate something. They want their unit back. It's not going to trial in most cases. But I do have clients that they're so fed up with this nonsense. They say to me, Mike, I'm not negotiating. Take it to trial. I'd rather pay you than pay that tenant. So, and we go to trial on this stuff. But there is still that option that the judge could say, you've got 5 days to pay that 25%. And in that case, shockingly, Chris, you would think that every tenant would be able to do it. A lot of them aren't. A lot of them don't. And it's not because of COVID. This happened even pre-COVID when we would get conditional judgments for habitability, where all they had to pay was a certain amount of the money, and they always claimed they had the money in the bank anyway. And the fact that they weren't paying rent had nothing to do with money. It was all because you were a bad landlord and you weren't taking care of your property. But when they got that conditional judgment, they still didn't come up with the money. So I hope that answered your question.
Yes.
All right.
Now, returning back to the tenant declaration just for a moment, if you provide the tenant declaration, the tenant did not pay rent on the first, you provide the tenant declaration as part of the documentation, as well as what else is required. They do not return that declaration. We can then begin the eviction process? That's
correct. If they do not return it within the 15 days, you can file an eviction. Now, caveat to that. We just talked about tenants having another bite at the apple. Here's another situation where the tenants get another bite at the apple. Let's say you're the landlord and your tenant doesn't return the declaration. You call me and you say, Mike, I want to file an eviction. I'm going to say to you, okay, Chris, we'll do it. But be aware that once we file that eviction and we serve the tenant with that summons and complaint, the tenant, within the same time period that they have to file an answer with the court, which is typically 5 days, they have the right to file that declaration with the court. And if they file the declaration with the court, the court is required to have a hearing within 10 days. And at that hearing, the judge is going to make a determination whether the tenant's failure to file that declaration or to return that declaration within that first 15-day period was the result of mistake, surprise, excusable neglect. And if the judge finds that any of those reasons apply, the judge is going to dismiss your eviction case without prejudice, which means you can bring it again. So I'll give you an example of how that would work out if you did that today. Let's say, and going back to what I was saying before about serve your notices every single month. Let's say your tenant doesn't return the declaration, you file your eviction, the tenant gets served, the tenant then turns around and files the declaration with the court. It's all judge discretion. The judge holds the hearing and the judge asks the tenant, why didn't you turn the declaration in? Because I was on vacation. Okay, you were on vacation and so you didn't return the declaration. That may be a situation where the judge says, that's not surprise or excusable neglect. That's inexcusable neglect. We're moving forward. I'm not dismissing this case. And we've had 3 tenants now return those declarations, and we've won the hearing in every one of those cases. We haven't lost one yet. But that doesn't mean we couldn't lose one tomorrow. So let's take a different situation. The tenant gets served the summons or the notice and the declaration, doesn't return the declaration. We file the eviction, we go to court, the tenant turns in the declaration, the court has the hearing, and the tenant shows up and says, listen, you're absolutely right. I didn't return the declaration within the 15 days. My wife had been in a car accident and there was a legitimate reason. I had other things on my mind, but I did turn it in and I have been impacted by COVID. I would put money on the case that in that case, the judge is going to say that's excusable neglect. Or the tenant says, I've received so much information about COVID now that I didn't really understand what I was supposed to do. I could see a judge looking up and saying, yeah, that's surprise or excusable neglect or inadvertence. That case could get dismissed. Now it's without prejudice. What does that mean? It means you can bring that case again. When would you do that? The following month, serve your notices again. And if the tenant fails to return the declaration the following month and you file that eviction, now he's got to explain to the judge why 2 months in a row he hasn't returned that declaration. But what is really more important for your members or your clients to understand is many of your clients are going to hear me right now and they're going to say, look, I don't want to spend $1,000 to file this eviction and have the court dismiss it. And that makes sense. I understand that thought process. But doing this every single day like I do and having been a litigator now for 15 years and being in court, what I know is that by filing the eviction and forcing that tenant to go into court and actually be engaged in this process, it's a great way to open the door to negotiations and settlement with that tenant. It's a fantastic way to tell the tenant, look, I'm not going to let this go. We are going to see this through to the end every month if we have to. I'm willing to spend the $1,000. Or you and I could enter into a settlement agreement where you agree to vacate by a certain date. And maybe I'm willing to waive the rent. All that back rent you owe me, maybe I'm willing to waive it. Give me my property back. That door gets opened only when the tenant thinks the landlord is serious. And the minute you file an eviction, the tenant says, okay, this landlord is serious.
And I think what's disheartening about the whole thing is, again, in speaking with landlords that are having issues right now, many of them have the assumption, okay, I just need my day in court because when I have my day in court, everything will be set aright. And from what you're saying is maybe not so, or maybe not the way they think it will be set aright. And so that finish line of, hey, just get the courts open, while of course it's progress and it's a lot better than where we are now, of course, still may not end up the way that many would hope it would. And many of them are going to be in a position where they're going to have to be, forgive several $1,000s of rent because during the negotiation process, yes, they'll get their unit back. And yes, that gets you one step ahead of the game. But all those previous months of rent may be lost. Yes, you'll get a judgment. And yes, it'll be handled as consumer credit debt from what I understand. but what's the likelihood that you're going to collect that money?
So that's a fantastic question. I don't know. If it pre-COVID, the likelihood was actually pretty good. If you actually went and got a judgment, as long as you didn't try to pursue it immediately and you just let it sit there for a while. So what would happen pre-COVID is I evict a tenant, I get a judgment against the tenant for some amount of money. And if the client hires me to do evictions, collections, you let that judgment sit there for a while, because if you go after the money right after the eviction, the pain of the eviction is there and the tenant would file bankruptcy. If you let some time pass and the pain of the eviction goes away and the tenant's reestablished, they're working again, they've got everything back under control, then you go into the collections process, they're less likely to file bankruptcy. Now, once COVID hit, what I'm seeing and what I anticipate happening is you've got debt that's piling up. And we're not talking about a $2,500 or a $3,500 judgment. We're talking about judgments that are going to be in the neighborhood of $10,000, $15,000, $20,000. What's going to happen if you get that judgment on that? The tenant's going to run and file bankruptcy. I can almost guarantee it. Why wouldn't they? Which is why a lot of tenants aren't paying rent right now. They're not paying a penny. They already have this planned out in their head. The minute these floodgates open, I'm just letting my debt pile up right now. The minute the floodgates open, I'm filing bankruptcy and I'm going to wipe out $25,000 worth of debt like that. And there's nothing anybody can do to me about it. And in a year after that, my credit's going to be better than it was today. So again, in that sense, landlords have to be cognizant of that while I know it hurts the landlords, it's very painful for them to understand that, but getting into the proper mindset and judging the whole situation correctly. Again, going back to what I was saying before, that's why you serve the notices every month. That's why you attack it now. Don't let it get to June before you decide to serve a notice. File your eviction now. Yes, you might lose $1,000, but it's aggressive. And you open the door to the better odds that you're going to be able to get into a settlement agreement with that tenant, get your unit back faster and get it back on the market and cash flowing again, and get rid of that one tenant who's not paying debt or rent, rather than waiting till June to do anything about it.
That brings us then to the money that is available, because if we know that ahead of time that going to court may not necessarily go all in the way in the favor of the landlords, do we take the money on the table? And the money that's on the table comes from this rental assistance program that was created by the federal government, and then each state is divvied out their portion. With respect to those monies, when will those monies be available? How do they work? How do we apply?
Okay, 3 different questions there. When will it be available? Great question. No definitive answer right now. As far as you are right, what you said is each state gets an allotment, I'll call it, of some of the 25 billion. California got 2.6 billion in total. 1.4, I believe it was, went right to the state of California. And then 1.2 billion is going to local municipalities so that they can administer their own program. Under the state has to begin accepting applications no later than March 15th. The local jurisdictions don't have that same requirement. And the challenge for everybody, state and local, was it was very similar to last year when the PPP loans were put into place. Everybody knew the money was there, and it was, but nobody had the platform in place to get the loans done. And the requirements were changing every single day. So you could submit your application and they would come back to you and say, hey, we need this now. Now we need this. And you'd say, hey, why do you keep changing this? And they'd say, because the federal government is changing this every day, what we need. That's kind of what's going on with this rental assistance program. The state is working quickly to implement the administrative component of it. And I think they'll be up and running no later than March 15th, the way they're supposed to. But the local municipalities, they're not as big as the state of California. They're going to face bigger challenges. Now, you talk about a county like Los Angeles that in and of itself is huge. They're going to be on it much better than some other county or some smaller county. So you can anticipate in March, roughly, whether it's state or local, that they're going to be opening up to accept the applications.
How does the money function?
Yeah, how's the money going to function? So under the program, there's different levels of criteria as far as who's going to qualify. Just because the tenant applies for it, and we'll talk about applying for it in a second, just because the tenant applies for it doesn't mean they're going to get the money. So let's unpack the system. The tenant or somebody, the landlord, could theoretically apply for the tenant. And the tenant is going to have to go through this screening process. The screening process works more or less like this. Priorities are given. The highest priority is going to people who are making 50% of the median income for their geographic location or less, 50% or less of the median income, which, if you think about it, is a really low number. They'll get highest priority. The next highest priority is going to be areas that were disproportionate, people who live in areas that were disproportionately impacted by COVID. So, for example, there's certain ethnicities that were highly impacted by COVID, more so than other ethnicities. Well, areas that have higher percentages of those ethnicities are going to receive the next level of assistance. And then the third level of assistance, or third in line, will be those households that are 80% below the median income of that location, or not below, they make 80% or less of the median income for that geographic location. So there are going to be a lot of people that apply for it that are just not going to qualify. And so in that situation, that landlord is not going to get those funds. So that's how it qualifies. Now let's talk about the application process. Who can apply? Well, the landlord can apply on behalf of the tenant. The tenant can apply themselves. The problem that I see that we're going to run into, or landlords are going to run into with trying to apply on behalf of the tenant, is no matter who applies, there's certain criteria that they have to meet, not the criteria I just talked about. Each household will have to demonstrate, for example, that they are either currently on unemployment or they qualify for unemployment. Well, how would the landlord know that? They wouldn't. They would have to go to the tenant to get that information. Okay, are you on unemployment? No, I'm not on unemployment. Well, do you qualify for unemployment? I don't know if I qualify for unemployment. And even if I did, I'm not going to tell you that. So the landlord, where I see the hurdle coming, is that the landlord is going to have to interact with the tenant in that application process and get the tenant to cooperate by providing the information that the landlord is going to have to provide. And I think that a lot of tenants, especially the tenants who are just really gaming the system and are really haven't been impacted by COVID, they're not going to want to give up that information, which is going to make it extremely difficult for the landlord to apply and get approved. But what I will say about that is, if the tenant doesn't comply and act in good faith, I'll say, that's going to come out in court. And when it does, it's also going to be revealed that that tenant was the tenant gaming the system. And so
let me stop you there for a second, Mike, because I hadn't thought about this. So the proof of that. So I'm a landlord, my tenant hasn't paid. I approach them and say, hey, there's this program. They say, sorry, don't bother me with it. The proof that you'll need that you try to do something as the landlord, I would hire, say, you as an attorney to serve some type of notice to show we did contact the tenant and they just never responded to work alongside us to apply. Is that the order of operations?
It is. That's one approach. What we're doing, my firm, is in addition to the notices, we've created a letter that we're sending out with the notice that says, hey, there's a program. You might be entitled to be able to walk away from 80% of this rent. But we need your cooperation. Here's what we need to know. And we know that most of the tenants aren't going to provide that information, but you're alluding to something that is required in SB 91. You haven't come right out and said it yet, but let me address it since you're already there. As one of the additional, and you asked me before, does SB 91 create any changes to AB 3088? And I said there are additional protections. One of the requirements under SB 91 now is no matter what kind of case you file trying to recover some of that rent or recover possession of your unit, whether it's an eviction, a small claims action or a civil case for breach of contract, the landlords are now going to have to meet additional informational requirements. For example, if you file a small claims action or a breach of contract action, you're going to have to attach as part of your complaint evidence or documentary evidence that you as the landlord acted in good faith to either investigate whether the tenant would qualify for the 80%, you attempted to apply on your own for the 80%, or the tenant wouldn't cooperate with you to get the 80%, or as a landlord, the tenant came to you with maybe a different program, maybe a county program or a city program, and you attempted to cooperate with their efforts to qualify for that rental assistance. So now as a landlord, you've got to demonstrate all three of those, that you did that in good faith going forward. So again, that's why we're drafting this letter. That's going to be our evidence when we file cases on behalf of our clients. Hey, we sent them a letter. We told them they could walk away from 80%. We asked them all the questions we would need answered to apply for them. They've failed to respond at all. They've refused to cooperate. How could we do anything more? We behaved in good faith. They behaved in bad faith. So for the people who don't use my firm, let's say they go out and serve their own notices. Yes, what they should be doing is hiring us afterward to write that letter to the tenant, to start that good faith requirement on their part, so that when they do go to court eventually, no matter how this pans out, they've met the requirements of SB 91, and they can demonstrate it with a letter from a law firm saying, we're here to help. And then the tenant, if they refuse to cooperate or comply, then we're going to throw it back on them and say, look, the bad faith here was clearly on the tenant. And there's additional mechanisms we can use to prove bad faith. In those cases, we can use discovery and ask the tenant, please provide us all the documentation that you submitted to any government entity in an attempt to apply for government assistance to pay your rent. And when they come up with nothing, then that's where the judge is going to look at them and say, so you were gaming the system. You didn't do anything. The landlord attempted to do everything for you, and you wouldn't even cooperate with them there. This is a joke. Yes, we're going to enter judgment against you.
So obviously there's to the money, there's like two pieces to this. The government will pay either 80% of the total rent, and as the landlord, you would then agree to forgive the other 20%, or the government would pay this minimum 25% that we've been discussing for them. Regardless of whichever program, is it mandatory for the landlords to accept it? Or can they take the stance, look, a contract's a contract. You owe me X money. I don't want 80, 15, 30. I want 100. Do they have to play ball with this program, basically?
So another great question, Chris. In general, if you're looking at this strictly from a contractual basis, like you just were, no, you don't have to participate in this program. You can say, nope, I want it 100% on the dollar, and I'll wait. I'm patient. There's some challenges with that. Now, I don't know how legal these challenges are. In fact, I don't believe they're challenges, but I'll explain them anyway. I mean, I don't believe they're legal, but I'll explain the challenges. First, SB 91. Well, let me back up. Prior to SB 91, I'll use the city of Los Angeles as an example. The city of Los Angeles and the county had a rental assistance program. The tenant could apply, and then the letters would go out to the landlord saying, hey, we want to pay a portion of the tenant's rent. And all you have to do is sign this document. And by the way, if you sign the document, you're giving up your right to evict the tenant for any reason for 12 months, and you're giving up your right to raise rents for any reason for 12 months. Now, most of my clients rejected it and said, we're not going to walk away. What if we need to evict them? We're not willing to do that for the money we're getting. So they wouldn't cooperate. They refused to apply to the program. As a result of that, and that was huge numbers, most landlords wouldn't cooperate with that. As a result of that, the tenants' rights advocates went back to Sacramento and said, look, the landlords aren't playing ball with us. We're trying to help them and they're not playing ball. What they didn't say was because hey, they're not playing ball because we're asking them to give up some really realistic and necessary rights. All they said was, look, they won't play ball. So what Sacramento did was they built in some procedural hurdles, I'll call it, to not playing ball. One of those, for example, says, if you're a landlord that refuses to cooperate with the rental assistance program, and that tenant were to have qualified for the program, when you go to sue that tenant in the future, let's say you sue them in small claims court for all the money they owe, even if the judge enters a judgment in your favor, Mr. Landlord, we are now going to give the judge discretion to reduce that judgment amount. Now, the law didn't state how much they could reduce it by, but if I were a betting man, I'm not, but if I were, I would bet that those judges would be reducing it by 20%, right? It makes sense. So there's a disincentive to landlords right now to refuse to cooperate and walk away from that 20%. Now, there's another interesting argument to be made, and it hasn't been made yet to my knowledge, but I can anticipate it. SB 91 specifically states that the rental assistance program funds are a source of income. And as all landlords know, it's illegal to discriminate against a tenant based on their source of income. And so while I haven't seen this yet, like I said, I anticipate that tenants' rights groups are going to point the finger at landlords who refuse to cooperate and say, look, you're discriminating. Your refusal to cooperate is a form of discrimination based on their source of income. So I know it just baffles your mind. Like I said, there's these procedural hurdles that are being put in place to landlords refusing to cooperate with this program. And candidly, obviously each landlord is going to have to make their own decision. But as the saying goes, a bird in the hand today is better than two in the hand in the future, right? Or whatever, however that saying goes, you get the point. Money today is better than a promise of money in the future. So if you're a landlord, and you're especially a landlord who might be hurting right now, the 80% might make sense for you guys to do, and to avoid the possibility that some judge is going to reduce your award later, or somebody's going to allege that you were discriminating by not accepting the payments. But again, you still have to apply for the 80%. There's no guarantee you're going to get it. And if you don't get it, then yeah, you've got that 25% portion of the program that you could still receive.
Now, I know there's some landlords thinking to themselves, well, you know what? I do have some of the tenant's money and it's in the form of a security deposit. What I'll do is I'll just deduct from the security deposit what it is that they owe me. And my understanding is that's not allowed, but is the fact that it's not allowed that you can't, as the landlord, just force that option on the tenant. But let's say the tenant agreed. You approached the tenant and said, look, why don't we make a gentleman's agreement here? I have X amount of security deposit. You owe me X. You're now catching up, but you still owe me this other amount. Let's deduct it from the security deposit. And they're in agreement. Did you violate SB 91 by doing that?
Technically, Chris, the way you worded it, yes, because you used the phrase a gentleman's agreement, which implies no written agreement. But if the tenant and you put that into writing, then that's perfectly acceptable. So let me go back. You are correct. You are not allowed to use the security deposit to pay unpaid COVID rent, which is defined as rent that accrued between March 1st, 2020 and June 30th, 2021. You can use that to pay COVID or non-COVID unpaid rent, which could have accrued prior to March 1st, right? That would be permitted. Or once the tenant vacates, if they vacate, even owing you COVID rent, then you would be allowed to use the security deposit to pay that as well. Now, right now, let's say the tenant is still in possession. And like you said, you approach them and you say, look, you owe me $5,000 and you have a $2,500 security deposit. Are you okay with me using the security deposit? The tenant says, yes, I am. Let's go ahead and do that. One, get it in writing. All right, put it in writing, make sure the tenant signs that writing. That's the only way that would be enforceable and legal. More importantly, this is what I want your clients to think about though. Do you really want to do that? Because when that tenant eventually vacates, and they will, you have no security deposit now. And I guarantee you that that unit is going to require that security deposit to help get it back in shape and get it back on the market and cash flowing again. So the only time I can think of that might be not the case would be if that tenant's been there a long, long time. They've always been very trustworthy. They already have a place to move. You know that's not going to happen. They kept the place immaculate. But in most cases, I would not use that security deposit. I would sit on it. It's the only money I have for any damage to that unit once they move out.
Now, you and I recorded a video prior when AB 3888 had just passed. And we discussed, as a landlord, how to protect yourself by not renting to somebody else's problem tenant. And we discussed checking with that previous landlord, was the tenant behind any rent, checking with the employer to see, are they essential? If there was a quarantine, would they be working? My understanding now under SB 91 is that unpaid COVID rent, or essentially them skipping out on another landlord, cannot be used as a reason not to rent to them as a new applicant at your building.
That's accurate. Unpaid COVID rent cannot be used as a negative factor or used to deny a tenant or an applicant tenancy currently right now. And I don't think that will change. First of all, if you call the prior landlord or you call a current landlord right now and the tenant is not paying rent, the odds are that landlord is not even going to be honest with you. They're going to tell you, oh yeah, he's a great tenant. He gave me his 30-day notice. It's just human nature. They want to get rid of their problem. And if you're the person to help them do it, they're going to help you. So that's one component of that. Two, let's say you did run into that person who's honest and said, yeah, they haven't paid me rent in 3 months. I'd love to get rid of them. You're not allowed to use that as a factor. Now, having said that, that doesn't mean that you're not allowed to still screen the tenants. So you're still allowed to go through all your screening. And if there's some other factor that would disqualify them, you're still allowed to use that. So what I would suggest right now, I'm just giving free legal advice, take it for what you paid for it. Consider increasing your rent to income ratios right now, right? So let's say you usually work on a 2.5 gross income to rent ratio, and rent's $1,000 a month. So that would mean they have to have $2,500 a month in gross income to the unit. Well, you might consider increasing that right now, maybe to $3,500. Use a multiplier that would allow you. Yes, it would make it more difficult for people to qualify, but on the flip side, it would give you a reason to disqualify somebody who falls into the boat of somebody who's not paying their COVID rent right now, right? So it would give you a legitimate basis for not taking a tenant on, and there's nothing wrong with it. There's nothing illegal about that. And in fact, I mean, given what we're facing right now and the condition of the economy, increasing your gross income to rent multiplier might not be a bad idea anyway.
Now, one final question, Mike. Again, thank you for your time.
Sure.
Many landlords have had the misconception that whether it be under AB 3088 or now under SB 91, it's somewhere in there buried was that you could not raise your rental rates. So unless your city that you own in has its own specific rent freeze or rent limitations, okay, so the individual municipality. But if your city doesn't have any type of said regulation, can a landlord raise rental rates right now?
It's a good question. So many questions you ask, Chris, are great questions. The problem is a couple of years ago, they were so easy. And now under this environment, they're more convoluted than I'd like them to be. The short answer is even putting your local municipalities aside, you still have to figure out if you're controlled by statewide rent control, SB 1482. Assuming you're not, then you still, yes, is the answer. You can raise your rents. But until March 31st, all landlords should be aware that Governor Newsom did enact that rent gouging penal code, and it applies to landlords. So even if you have no restrictions on you whatsoever, don't increase your rates greater than 10% because you would be in violation of a criminal code right now for what they call rent gouging in a state of emergency. That's valid until March 31st. Putting that aside, then again, like I said, you could raise your rents, assuming you don't fall under statewide rent control. I mean, let me rephrase it. You could raise your rent. The amount to which you can raise their rent will be determined by whether you fall under statewide rent control.
Thank you for that. I can just see landlords watching this saying to themselves, I just want my rent.
Yes.
I just want my rent.
Or my unit, one or the other. I want my rent or my unit.
And that's why it's so important to have an attorney like yourself in your corner as a landlord, because to try to navigate this thing, and even though, Mike, you've done a very good job at outlining the documents that's needed, the timeframes, even still, as I've instructed my own personal clients, why go it alone to then have your case thrown out due to a technicality because you're not an attorney, and even amidst your best attempt, you didn't dot an I or cross a T. They really need an eviction attorney in their corner. And Mike, again, you've been very gracious with your time. I know that you take simple email questions and so forth, and you readily answer those for landlords. But the other note I'll say to that is, if a landlord is going to need something beyond a simple question, or they really need, Mike, they need your time, they should be prepared to pay for a session to sit down with you, whether it be via Zoom or what have you, to get that advice they need. Because again, to try to go it alone, to save a few bucks, to only lose in the end, to me, just doesn't seem to make any sense.
Well, I appreciate that. And I will second your position. Anybody who's ever worked with me knows that I provide a tremendous amount of free information, free services. I'm not out there gouging people. What I'm running into now that ties in directly to what you just said, Chris, is you asked me when we first hopped on today, how are you? And I said, I'm very tired. It's just exhausting. Answering the calls, answering the emails. Simple questions are easy. I don't mind firing back an email, etc. What I'm running into is there's only 24 hours in a day. And a lot of the people that shoot me the email, especially people who have known me for years and are used to me being willing and able to respond to an email without charging people, they're getting very frustrated because it's taken me quite a while to get back to them. And so what I would say to you or add to you is, please understand, I'm, as a landlord attorney right now, we're going through the same thing the landlords are. A lot of our regular clients can't even file evictions. My business has been impacted significantly, and I'm working harder than I've ever worked. So with that in mind, a simple question, I'm happy to answer. But as you can see through this webinar today, a lot of these questions that a landlord might think are simple, they're not simple. They're very, very nuanced. They require multiple questions for me to give a proper answer, and they take time. And if that's the case, then yeah, I'm happy to sit down with people and do it. But yes, it's very likely that I'm going to say, we need to schedule a 30-minute Zoom seminar or Zoom conference call rather. And I charge a minimum half hour, and we'll sit on there as long as you need. But it's something we've got to be compensated for, because it's too much time taken out of my day that I really should be working on cases that are pending. So I don't want to seem like a guy who's just money hungry and always looking for the last penny. I'm not that guy, but I also am not the guy who can spend 20 or 30 minutes on a call with people to answer what they think is a simple question without compensation anymore.
Well, no, and I don't think anyone could accuse you of that. I know between our educational webinars, the other Zoom sessions you and I have done together, you've already shared with our clients, landlords at large, a few hours of free content, and they should be more than happy with what you've offered so far. Mike, again, I want to thank you for your time. Be well. Obviously, these are interesting times, and until we see each other again.
Thank you, Chris. They are interesting times, but as the saying goes, this too shall pass.
Yes, sir.
All right. Thanks, Chris.
Thanks, Mike.
Bye.
I hope you found today's show informative. I hope the information that Michael Brennan shared helps you. If you've had issues the last few months dealing with tenants, collecting rent, running your multifamily properties, I hope this information at least sets you on the right path to know what to do next. And from there, you can hire the right professionals that can assist you and help you tackle whatever situations you may be facing. But I hope in general, most of you are having no issues. And this is more so, just for your own information in case something should happen. I hope that your properties are performing well. And I hope your tenants are behaving. Be sure to like this video, subscribe to our channel, and turn on the notifications so that you can continue receiving this information as we either interview other professionals that discuss owning multifamily properties, or as we continue to bring you those topics within those areas of interest that will help you build your financial legacy in multifamily properties. Chris German from The Apartment Dealer, and as always, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.